All right, welcome everyone. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for February 9th of 2026. Brad, go ahead.
I'm sitting here in a hotel, so if the audio, visual, or internet sucks, not my problem. I got court
Well,
tomorrow.
that was, and I want to apologize to everybody. I don't know what happened last week. It came out awful. And when you and I were recording, now I know I was actually using the Wi-Fi from my cell phone, and I've never had a problem with that before. And
It was skipping and freezing you, and
yeah, well, so you could see that on your end?
yeah, I could see it on my end.
Because I couldn't see it on my end, and you were fine. So, all right, well, make sure we gotta watch that. But apologies to those who, and I know several of you wrote into me, but it's really out of my control. And if I see it, maybe I could do something about it. But I didn't even see it on my end. So,
Yeah, well, at that point, we're recording. So,
yep.
okay. Anyway, let's start in Austin, where we have a female fire captain who's been suspended indefinitely. She's accused of, and I got to tell you, I'm kind of taking her side on this. She's accused of timekeeping fraud.
Hmm.
So she is accused that she falsified time records spent doing inspections and stuff of buildings, and that the city now says, well, that's a violation of our policy. She's been there 13 years. There was an inspection, and it says she did these new, she and other people, right? But she did these new construction inspections. They build them at a standardized rate based on factors like building size as opposed to the actual time spent. Now, she says, but that's how we've always done it. We've followed the kind of unwritten policy of the state or of the city, sorry, and that, she's just following, doing what they've done. And they accuse her of, bilking the time. Um, they also found, and this isn't the good part, that she used a city issued vehicle for personal errands and medical appointments. We'd have to know more about that. Sometimes I look at those as just somebody trying to wipe a little more mud on your reputation than they need to. But I do have questions on this, right? If
Yep.
she was just following how everybody does it,
Mm.
then shame on the city for not catching it.
Yeah. Yeah, it still is not clear to me how the whole thing progressed, but I think most of the fire inspection and plan review billing that I'm familiar with is a set price. It's not based on hours. It's based on set price. So, but it sounds like they estimate the hours and that or bill for certain hours, and then she thought if it said it was going to take her 6 hours to do something, she puts in for the 6 hours. And whether I don't know. On the other hand, just because you've been doing it, uh, for a couple of decades that way doesn't mean it's not. And one of the other things that didn't kind of make sense here is if she did commit that kind of payroll fraud, why weren't there criminal charges? Usually, criminal charges come out before the discipline comes out.
Is it payroll fraud? Is she personally benefiting, or was it the city who was benefiting? And I wasn't clear on that from reading it.
Yeah. Yeah, no, there's a lot. And unfortunately, you and I are used to reading cases and we're used to reading complaints and court documents that kind of flush out a lot of that information. And here we're going secondary information, what's available in the news media. So
Right.
it's not clear.
If it didn't benefit her personally in any way,
Yeah.
then why is she being charged, right? There's
Yeah.
there's no intent to benefit herself. What's she doing wrong?
Right.
And I'm not saying that, look, if the city's overcharging, the city's overcharging, but
Mhm.
after that many years, the city, the employer's got an obligation to do some audit, and they've said, "Oh, we're looking." Well, wait a minute. If now you're going to walk in to correct it, don't
Yeah.
punish your employee
Well,
who's been doing it right or
Chief
wrong.
Chief Baker's a friend of mine, a long time friend of mine, and he was originally from Atlanta. I first met him he was, I think he might have actually been a battalion chief or deputy chief in Atlanta when I first met him. But bottom line is he's relatively new, and Austin's a big fire department. So for somebody to come in, I know he's been there a few years now, but for somebody to come in and try to get your arms around all of the problems in an organization, at some point you got to kind of look back to the predecessor chiefs who, either set this up or allowed it to be set up. So,
Right.
but we'll see how it all shakes out.
All right.
Yeah.
Well, speaking of shaking out, horrible, bad pun intended. Let's go to Baltimore County. That may be the worst thing I've said.
I'll tell you, you can't make this stuff up, and you can't. You just can't.
So
So,
we've got a Baltimore County paramedic. First, there's dumb, and then there's stupid. This gets both, if it's true.
there's dumb criminal and a dumb, and then there's criminal, and
Right.
this is truly criminal.
And stupid, if it's true.
Yeah.
But so we have a Baltimore County paramedic. He's now under investigation, had been under investigation, and now he's criminally charged. But again, just charges, not finding of guilt.
Right.
He's, 36. You think based on the allegations, he'd be like 12. And he's facing now 23 criminal charges, which is disgusting when you think how those 23 came about. He knowingly and willfully, allegedly, caused another person, like maybe 23 other, to ingest bodily fluids. So how does this come about? Well, it comes about out of some stupidity. So he first is somebody makes a complaint, but he's been bragging about it online, right? And so a traffic stop happens. I assume it wasn't random.
Oh no, they had a search warrant. They were going for him, and I think they wanted him. They wanted to get to him before he could delete what was on the cell phone.
Right, but that was, I think, after the traffic stop was the search warrant. I don't know, according to the article, he does this traffic stop, they seize a cell phone,
Right.
and then after that, they execute a search warrant, well, at least at his residence. So I don't know, maybe they have a search warrant for his vehicle and his phone. I don't know, I can't tell that. But
I mean, this goes back. This goes back a while. We had first, I think, talked about it early in the fall or later in the fall of last year, November of 2025.
And the specifics are disgusting, right? He engaged
Yeah.
he allegedly in both ice machines and coffee creamers that he
Don't even say it. Don't even say it.
There are bad liquids, fluids in there, and people drank it. And so he recorded the activity, hence the search warrant, then uploaded the videos to a pornographic website and to social media. That's the stupid part. If that's true, just Jesus Christ. In any event, and to further stupid, it's his username got him in trouble, but his uniform also did, as well as a distinctive tattoo. Why are you wearing your uniform when you're doing this stuff?
Well, I think that goes to a person who would do something like this doesn't see the wrongness of it. They miss that, whether it's biological or neurological or psychological, they don't see the problem with it. They just think it's funny. And the rest of us are disgusted.
Yeah. But how do you think that's funny? Like, that's a depravity issue, right? You are so depraved if you really think that's funny.
Was it Caligula? I mean, they don't see it. They don't see it.
I'm sure you covered this in your master's, but Jesus.
Oh yeah, no, it's right down Broadway when it comes to forensic psychology. I think what's unusual is people with those kinds of interests don't usually find their way onto fire departments or positions of paramedic, where they have access to a credibility that's built into our positions. And it's I don't know. I mean, I don't know if they don't do psychologicals on these folks. This should have been I would think this should have been obvious on a psychological.
And so many departments don't because they just can't afford it.
Yeah.
Police departments obviously very good about it.
Police have to because they've got guns, and you can't have somebody with a malfunction upstairs running around with a gun. So
the fire department, what are you going to do? So I mean, I wish we could. I wish we do, but we just right. It's what do you think? Maybe like 5%, 3%. We're making this up, but I don't think big cities might do psychological evaluation.
Yeah, I know in Providence we did. In Providence, we did, and I know, a bunch of my sons. My son is a police officer, and a bunch of his friends, kids I coached in Little League, and right up on through, to Babe Ruth and amateur league. They all became police officers, and they all had to go through, a real
police, of course,
serious. Right. Yeah, no, absolutely, absolutely.
Fire, don't do it.
Yeah.
No, we're lucky if we do background.
Yeah, we always say, "Oh, what could happen?"
Right.
If we don't do this, oh yeah, what could happen?
Apparently this, right?
Here's
Apparently
Exhibit
this.
A.
Yeah, exactly. And your database has beat at triple Z, but yeah. Okay, let's boy, I can't even say let's get off of that. But let's not say that. Okay, so federal judge, I hope people are watching this laughing their proverbial butt off. But okay, so let's move on. So now we're going to go to South Carolina. This is from a legal perspective, super interesting, deserves a lot of conversation. So here's what we have. Let me give the general facts are pretty easy. The court has all the court has said is we're not dismissing most of this case. So, but the why and what's going to happen is interesting. And if you're a union president, you better pay attention because, well, the question of what capacity you're acting in is always going to come up. So we have a federal trial court level. In South Carolina, there was a motion to dismiss the lawsuit. It was made by the defendants, the city and the fire chief, and they were sued by a firefighter, which is strange to me. Maybe you understand this. Allegedly, he's a probationary firefighter, but he's the union president.
Well, let's start. Let's kind of even back up a step. Okay. The National Labor Relations Act applies in private sector, but it has no relevance other than, it's persuasive in the states. Each state can make a choice about whether or not public employees can collectively bargain or not. So, and there's a term there, right to work state versus, and that term is actually misleading. Okay.
Very, it's the opposite of what it says.
Right, exactly. So, but in some states like New York, like Rhode Island, firefighters have the right to collectively bargain. In some states, they don't. So there's two categories, right? Now, there's a third category. The third category of states that have made it illegal for public employers to bargain with their employees. South Carolina is one of those states. So it is illegal in South Carolina for the fire chief to bargain with the union. Okay. So the union in that case is more or less a social club. It's a place where folks can come and talk over their problems, but they have no ability to bargain. So you have this firefighter, and as I understand it, he got on the job, I think in 23. He was on for about 6 months. He moved down to Florida, was a firefighter down in Florida, came back, and he had been on the job a couple of months coming back, and he got elected union president. Okay. Now, I don't know if he saw how things were being done down in Florida or how things maybe he knew were done in other states, maybe that had a different set of laws. But the fire chief cannot meet and negotiate with the union. And, why would somebody with only a few months on the job become the union president? I don't know, Brad. Why would that happen? What do you think? Nobody else wants it.
Right. Take the new guy.
Yeah, okay, kid, here you go.
It's Mikey. Mikey likes it. Mikey eats anything.
Go for it. Okay. So at any rate, he's still on probation, but he's the union president. And now he wants to meet with the chief, and the chief says, "Look, we can't bargain, but go through the chain of command, and we can have a meeting."
But the topic is important. It's about morale issues, right? Things to make it a better place to be.
Absolutely. So,
which is not really a term. It's a term of and condition of employment, but it's really not. Right? I don't think it would be a subject of mandatory bargaining, even if we were in a different state.
Well, let me kind of. I recall having a conversation. I had been on Providence maybe about 15 years, and a firefighter came in, and he had been on, I don't know, maybe 3 or 4 years, and he comes to me and says, "Things have never been this bad. The whole time I've been on the job, things have never been this bad." And I'm like, "You've only been on for 3 years.
Yeah, things were worse before.
What are you talking about? Right. This kid's only been on for a couple of months.
Right.
I mean, give us a chance. It'll get worse. Trust me."
Right.
So, but at any rate, he wants to talk about morale. Okay, fine. All right. And maybe morale was bad. Okay. And certainly morale would be, a matter of public concern, I would think. Okay. But at any rate, he starts going down some other avenues with a city council person, I believe, and then I forget, who did he reach out to? Oh, city
Well,
manager.
first he reached out, right, as you said, to the fire chief. Fire chief said no, but respect the chain of command,
Right.
allegedly, right?
Yeah, and respect the chain of command and go through the chain of command to set up a meeting. I'm happy to talk to you.
Yeah, yeah.
Okay,
And instead he goes around it.
which is appropriate for South Carolina. In Rhode Island, it'd be an unfair labor practice. The chief has got to meet with the union.
Right.
In New York, it'd be an unfair labor practice. In South Carolina, it would be illegal for the chief to meet with them in his capacity as the.
But here the chief is saying, you know, you go through me, even though he said, I'm not meeting with you, right? So just because people are going to ask, if we're in a different state, right?
Yep.
A collective bargaining state, New York or wherever, and the chief says, you have to go through me, but I'm not talking to you about it. You still can't, in my belief, you still can't go over his head because it's still outside the chain of command. You can file a grievance.
If you're doing it in your capacity as a union president, you probably can.
Right.
Okay.
You file the grievance. You just,
That's not, I don't believe that's really what happened here. I think he wanted to meet with the chief in his capacity as a union president. And the chief said, no,
right.
We're not going to bargain. But if you'd like to meet with me, firefighter to firefighter, go through the chain of command. And I know in Providence, if you wanted to meet with the chief, you had to go to your lieutenant or captain. They would sign, you'd put in a Form 17, I'd like to meet with the chief. They would sign it. The battalion chief would sign it. The shift commander would sign it. The chief of ops would sign it. And then it would get to the chief. That's the chain of command.
Yep.
You don't just call, hey, chief, this is Firefighter Verona. I'd like to speak to you.
Right.
Like,
and then the letter he sends, though, goes way beyond morale, which is what allegedly he was supposed to do.
He starts going through a council person, and then he goes to the city manager. And again, maybe he just didn't understand state law in South Carolina. Okay, maybe because of his maybe other affiliation with other states where the law was different, he had a misunderstanding about exactly what a union could and couldn't do.
Right. And so what we're going to get to is basically First Amendment issues, right? But so the grounds of his discussion with the city manager was safety during emergency calls. To me, that's not really a morale issue. That's more of a operational issue, right? It may affect morale secondary, but training procedures, apparatus organization, class availability and funding, shift scheduling, and then a policy which restricts firefighters from congregating in apparatus base.
Sounds like concerted activities.
Not only concerted, right, it's concerted activities, but also most of these, like safety during emergency calls, issues of public concern, matters of public concern, right? Which is how I'm looking at for the moment. And so he then meets with the chief. Chief terminates him because you went to the city manager, you went to the council member, now you're corresponding with the chief without going through the chain of command. And because he was a probationary member, as a firefighter, he has no internal appeal rights. So he sues, right? He sues under 1983, primarily retaliation for protected speech. Also, interference with right of association based on his union role. I don't know how strong he'll be on that.
Well, that's interesting because usually we talk about free speech, and certainly there's free speech here, okay? But freedom of association, here's the other one that's it's buried in there with the freedom of association, the right to petition government for a redress of your grievances.
Yep.
Okay, and he's alleging that strain of First Amendment. All three of those kind of get merged into the First Amendment.
Right. And then, so for at least the freedom of speech portion, we have a Pickering test, right? Where very, very basically, we're just saying, are you speaking on behalf of the government or individually? In this case, he claims he's speaking on behalf of the union. So that's not the government, right? He's not speaking as an employee. I'm sorry. He's not speaking as an employee. He's speaking as a union member. And we know from many cases that would be protected. And then the question is what he's speaking on a matter of public concern? So they make a motion to dismiss. The court says at this stage, he's said enough to get past the motion to dismiss. So they deny the motion to dismiss on a number of reasons, but clearly the First Amendment, the freedom of association, as you said, is kind of wrapped in. And all the court's saying is, listen, at this stage, he's at least alleged enough that he's being terminated or punished because of his union advocacy. And he has, as he claims, the law says he has the right to associate with and advocate through a union, even where, this is the big part, the public sector collective bargaining is not required. Right. So it is a social club, but the court's saying you got some rights. right?
Yeah.
Freedom of assembly. So
Yeah. No, absolutely.
they kick
It's
out some of it, but not all of it.
yeah, it's an interesting approach to this problem. But again, why is someone with only a few months on the department, number
Right.
one, serving as union president, number two, trying to interject themselves into some really complicated problems. You start talking about staffing and funding and some of the other things that
And
he's
safety on
getting
fire
into,
scenes, which is the chief's province.
I don't know. Again, if this was Rhode Island, New England, where firefighters have a right to engage in collective bargaining up to binding interest arbitration, this comes out a little bit differently.
Yep.
But
He
we'll
also
see.
should have said whistleblower, by the way.
Possibly, yeah, if he's going to claim that, it was whistleblower retaliation, yeah.
Yeah, we're unsafe on a scene, a matter
Mhm.
of clearly of a public issue, but we're unsafe on a scene in many states. I know New York, some other states have something that says if you're complaining about, like in this case,
Mhm.
OSHA, right? The OSHA mandate that every employer has to
Well,
provide a safe place, and he's complaining about it, he would
yeah.
be entitled to whistleblower
Yeah,
protection.
yeah. Now, again, I think sometimes whistleblower gets kind of thrown around. You and I understand it, but folks think that anytime you report something, you automatically have whistleblower protection. There's two types of whistleblower laws. Okay, one is specific to the law that you're alleging a violation under, such as OSHA. If you complain to OSHA about something that's unsafe and you get retaliated against, that would be a violation of the whistleblower provision in the OSHA law. There's a number of other laws that have that kind of thing built into it. Okay. But when you complain about things that don't fit within that one little sort of, cubbyhole, then some states have a sort of generalized whistleblower law. I'm thinking South Carolina does not have that sort of catch-all whistleblower law. So you make a good point. They do have state OSHA in South Carolina. So if he couched some of his concerns in terms of an OSHA violation, or more importantly, if he had complained to OSHA about it, he may be able to trigger that OSHA-based whistleblower.
And look, I think the lawyer has proven, right? His lawyer has proven he's fairly competent. He survived a
Mhm.
motion to dismiss and drafted a complaint in a way where the court liked it, right?
Yeah,
So I'm sure he or she considered everything.
yeah,
Okay, in any event, this one's a little more confusing, to be clear. We're going to go to the FDNY.
yeah.
You and I think a year ago said, okay, let's just stop covering some of these, COVID cases. But this one creeps up in a different way because they're all being denied, right? There's no protection from, vaccination. If they want to fire you, they could. But this one's a little different. Because here we have I'm going to try to summarize this and then expand it anyway. But here we have an employee who was fired because he refused to get the COVID vaccine. He claims, as a Roman Catholic, he's not allowed to get it because he claims, I don't know where this is coming from, but he claims that the vaccine uses aborted fetal cells.
Yeah, I've never heard that argument made in them. Yeah.
No, and I'm not sure it does. To my knowledge, this has so been rapidly produced. I don't, but I'm not saying it doesn't, but I never heard that.
Mhm.
In any event, he said, look, the city, and I guess, kudos to the city of New York, but the city had a process whereby somebody on a religious or medical grounds could allow for a reasonable accommodation.
Mhm.
And they granted hundreds of them, apparently. And the accommodation is just keep submitting to PCR tests, right, in lieu of vaccination to show that you're not exposed. So I wouldn't argue that's a reasonable accommodation because you've got to be positive to be exposed, right? And you're still infecting people. But anyway, the FDNY says it was a reasonable accommodation and they grant it. And he was clear that my reason I don't want it is due to the abortion-related materials in the vaccine development, I guess. And so the FDNY denies the request. And the city also rejected his objections based on fetal cell line concerns, right? So maybe they never heard of it either. You and I aren't the only ones. So I don't know. I kind of want to Google it, but
Well, and he claims his beliefs go back to the pre-Second Vatican Council approach to certain things, and he's alleging that FDNY, if they went to verify his beliefs, went to a post-Second Vatican Council perspective on these things, and when they said, "Yeah, no, that's not a problem for us," figured that his beliefs were not valid.
right. And of course, they still have to prove that his belief is factually correct, right? That there are
Well,
fetal.
that'd be part of it. But again, I'm not even sure that that's really what I think precipitated the lawsuit, right? Because
No,
he
what
was,
precipitated the lawsuit is that in 23, the city amends their mandate. They
well,
remove
let's go back. He was fired. He was fired in 22, I guess, or 21, 22. A
right.
year later now, the city amends. Go ahead.
Yeah, the
And
city
city amends.
amends the mandate for 23, and he wants his job back. The city tells him that's fine, right? We'll give you your job back, but you cannot have back pay, which would be kind of, hey, the FDNY screwed up. You should have had your job. We're going to give you back pay. And so what this lawsuit is over is really the same thing, is whether he should have been able to be terminated or had to be granted a reasonable accommodation.
Right. That's
And
issue one. And whether or not they were justified in forcing him to waive that 1 year loss of wages part of the
right.
suit.
And I think it all comes down to the question. I think it comes down to a couple of things. Look, the city has a reasonable accommodation. The question is, were they required to do it? My first question, I really want to Google this, but I won't while we're on, is does this vaccine have any fetal tissue in it to see whether it's factually correct? I just don't think it does, but I could be totally wrong. We never
You
heard
think that
anything
would
about it.
I mean, if he was sincere but mistaken, is that a grounds for termination? How?
Yeah, yes, if you're mistaken, I think you still could be terminated. You're wrong. We don't need to accommodate you because that's a false belief. You got to be right, right? It's like, you got to accommodate me because I'm blind, but you're not blind. Yeah, but I said I am.
Yeah, no, that's a little no. That's if his religious beliefs are such that he can't he can't take the vaccine.
Then he wins.
Right, but even if the beliefs are based on a mistake.
Well, if those are truly his beliefs,
Right.
he would win if his beliefs are justified, meaning that the vaccine really has prenatal tissue. But if it doesn't, then how can you claim, well, I won't do it because of this, but the because of this is not true?
Well, there's a lot of people with these crazy ideas out there about conspiracies and different things, and their beliefs kind of feed into a sort of a mistake at the beginning of this conspiracy. And I don't want to get into the details of that beyond this, but if he is sincere, but he's just mistaken about the aborted fetal cell connection with that, he still has a sincere belief.
And here the court must have bought that because they hold, which isn't landmark, but if none of this was true, you think they would have got rid of it. The court says that the complaint at least makes sufficient allegations, like we talked about in the prior case, of both free exercise clause and establishment clause. And, the city, they said the complaint correctly alleges, and these are just allegations to survive an early motion to dismiss, that the city correctly rejected, or that the complaint says the city rejected his request because his objections were based on personal religious practices and because the decision makers evaluated, as you just said, the Catholic doctrine, and they were assessing whether it was legit or not. That the court says is enough, right, if true, to win. So it could have been rejected because the beliefs were considered idiosyncratic or inconsistent with institutional positions, and that is a constitutional issue. To me, and then there's a question of fact, of course, whether they could have accommodated him, whether that would have created an undue hardship. But how could it have created an undue hardship? They did it for 105 other people where they said just keep taking the test every week.
Right. And I don't understand why they didn't just throw him in with the rest of them and say, fine, you want to do it that way, do it that way. you know, you don't want to get the vaccine, you want to do it the other way, do it the other way. But he also made an argument that we saw. I think the first one we saw was out of Washington State, where he brings in mutual aid and
Yeah,
says
we
that
addressed this.
if this is such a serious thing, it's public safety, and you absolutely have to positively have this vaccine, then why are you allowing people with, you know, mutual aid departments that don't require this to come into the city? It's not really all that serious. So I think
That's
that's
not
an
a new
argument.
argument.
And let me just say, YouTube bots, please. I'm talking about what's in the lawsuit. I'm not advocating for anything.
Right.
The YouTube bot, just so folks know, the YouTube bots go through our dialogue here, and if they think that we're advocating for something instead of just talking about what's in a lawsuit, they ding us. So just
Yeah.
want to make that clear to the bots out there.
Which is why we can't quote certain words. We
Oh
can't
my
use
God.
certain words. It's talk about
Jeez,
First
we got a site we talked about. I don't even want to say the word, but
Right. Nope. Don't say it.
it's yeah. So it begins with an S, and it has to do when someone takes their own life, and you know, apparently that's one of those buzzwords that you're not supposed to use on YouTube. So
Even though we advocate for support and help and whatever. Anyway, okay, different
I know,
issue.
terrible, terrible.
Yeah. So in any event, so at this point, a federal magistrate who's like an assistant to a judge, they write the first decision, then the judge can accept the magistrate's recommendations or change it entirely. Here, this is just a magistrate who's recommended that the city's motion to dismiss be denied. I'm guessing the judge is going to deny it, but I'd still, why isn't anyone talking about whether there's fetal tissue in this stuff? Unless it's so conclusively established that there is, I can't get past that part. Anyway.
I don't know, but I think the decision was well reasoned, and it doesn't mean, again, like the last case we just talked about, it doesn't mean he's going to win in the end. It just means that they're going to be allowed to continue with the suit.
Right. Okay. Yeah. So we got a long way to go. I will just tell you that I Googled it, right? Whether the 19 vaccine has aborted fetal cells, and the answer is consistently no. In fact, the National Institute of Health, to the extent that anyone wants to trust them, but the National Institute of Health has an exact article on, and let me start reading. Many persons with religious convictions report hesitancy about COVID-19 vaccines, in part due to ethical concerns that fetal cell lines are used in development of certain vaccines, and they say no.
Okay, so that's good. So now we get back to my point here is, and I'm not advocating. I'm just questioning. I don't want anybody to think that I'm advocating for something here. I'm trying to understand it. If he was wrong, but he was sincere in his wrong belief, is that still religious discrimination?
And I don't see how it can be. So I don't know. And there's a million, I got to tell you, there are a million articles on this about it. I'd like to see I'd like to see an actual study, but certainly the manufacturers know whether there is or isn't. And the NIH is coming up. It's and again, this is very long, so I'm not just, I'm obviously not getting through it, but their response number 4 says administration of vaccines is not developed in fetal cell lines. But they say that for those patients who refuse a vaccine that is developed in a cell line and that was derived from an abortion, alternatives exist. They say, for example, the mRNA vaccines, which there were, Pfizer and the other one, right, were mRNA, as a class, they are not designed, developed, or produced in fetal cell lines. So how are we getting past that part? How does he get past it?
But again, I get back to what I said. If it's a sincerely held mistaken belief, can it still be, religious discrimination?
I'm guessing, but I say no.
Yeah.
How can it be? It's like saying you have a disability, but what your disability is not a legally recognized disability.
There's a lot of things in religion that people can debate. Not getting specific on any religion, but certain tenets on religion about what they believe God wants, or
this isn't that. This is whether if that fetal cell is really there.
The principle of it's factually correct or it's factually incorrect, or it might be, but it shouldn't be, or is or isn't. Yeah, to me, I think it comes down to sincerely held religious belief. And if it is indeed sincerely held, even though mistaken, I think it's still entitled to protection.
Yeah, I don't know. I'm dealing with a guy who's the clerk for the Supreme Court, so maybe I'll ask him.
Yeah, it would be. Yeah.
But I say no if I agree with your premise, but if it's not like saying we're debating whether God exists.
Right.
We're debating something that's easily proven. You either use fetal cell lines in your development of the mRNA or you didn't.
Yeah.
So anyway, whether you believe someone did is crazy. Right? You did or you didn't. But okay, well, let's end with this. This is unfortunate. And this trend started, I don't know when it started, but it's certainly becoming much busier in the last 3 or 4 years. We have a fire truck operator who just made a left turn in front of a bicyclist. He was not responding to a call. His lights and sirens were not on because he wasn't responding to a call. And he cut in front of a bicyclist, allegedly. And he killed him after a couple of days of suffering. So that's a complaint. He, unfortunately is charged with negligence and driving the truck. Probably there is no statute that protects the driver because he wasn't going to a call. And in fact, so he was charged. I don't know if he was convicted or pled to. All we know is he was charged with unsafe movement and this is North Carolina for in violation of a vehicle and traffic law. But I don't know whether he's convicted or pled to it. And being convicted or pleading to a traffic ticket is some evidence of negligence, but it is not absolute proof, but it doesn't help. In any event, this lawsuit's a single claim of negligence. You took a left turn in front of somebody, and if that's what happened, it happened. And, which is why dash cams. You should have dash cams. People should drive like they are being watched. That's the benefit of a dash cam. And, there will be no issue. If you did make an unsafe turn, then fine. But, what if he was flying? What if the guy was in the wrong lane? What if
the fire truck had a green left turn signal?
Yeah.
Right. And again, it shouldn't happen, but I know many bicyclists don't pay attention to red lights. They just as long as it's clear, they feel it.
They have the right away,
and they can
So dash cams would protect against this. And if you're guilty, I still say you're being protected because going through 5+ years of depositions when you're lying or your memory's unclear, right, or your memory's incorrect, why not just not go through that and say, here's the dash cam, we're either right or wrong. Dash cams end a lot of stress on both parties.
I agree. I'm a big fan of dash cams and also body cams. I think a lot of especially for police officers, but even some of our medics and some of the stuff that they've got to put up with, a lot of nonsense at the scene, can be better addressed that way.
I'm glad you said that. About an hour ago, I got a call. I won't say who the client is, but from another client. They will be the second, arguably, we allegedly believe they will be the second EMS agency in the state of New York to mandate body cams. Now, very interesting, just so you know, in New York State, starting, I think, in April, patient compartment cameras need to be, must be, I think those are implemented, but dash cameras facing forward are absolutely have to be implemented. So in New York, ambulances are going to be required to have dash cameras. I think there's a rear-facing component, patient compartment component. I got to see that, but I just got a call from someone saying they're going to wear the body cameras. And I think Lake George is the first fire department or ambulance, and then these guys will be the second. But it's a trend, and you and I like it, right? We like body cameras.
Yeah, it's going to document what actually happened. It's
right. So, okay, well, that's it. I got to go.
Another crazy day. Good luck in court. You in court today or tomorrow?
Tomorrow at 1 o'clock, people can watch at 1 o'clock. Well, I'll probably be on around 2, but if you want to watch it, go to just Google New York State Appellate Division 3rd Department, and you'll see a live feed of the oral argument, and we'll talk about it next week for sure.
Okay, super. All right, that's going to do it for another edition of Fire Law.